Hello, everyone. My name is Fred Quenzer, Assistant General Counsel here at ISDA, and this is the ISDA 2019 German Bank CDS Protocol webinar. Today, we will have Andrew Lally from Bank of America, who is also the Credit Steering Committee Chair, David Benton, a partner with Allen & Overy, Paul Allen, a Senior Associate with Allen & Overy, and myself to go walk you through the purpose of the protocol and to answer any questions. I will note that although we have scheduled an hour, we don't anticipate this will take longer than 20 minutes of us speaking, and then we will provide 10 or 15 minutes of question and answer after our piece. So with that, I will turn this over to David.
Okay, thanks, Fred. So the background to this is the change in German bank law that occurred in the middle of 2018, when European banks introduced the concept of senior preferred debt and senior non-preferred debt in 2015. Most jurisdictions allowed their banks, introduced statute that allowed their banks to specify at the time of issuance of the debt whether it was to be senior preferred or senior non-preferred. And although technically senior non-preferred is not subordinated to senior preferred in the technical sense, for CDS purposes it effectively is. Senior non-preferred absorbs losses ahead of senior preferred. And so in effect, for CDS purposes, there is an additional layer of subordination of debt. You have the senior preferred at the top, then the senior non-preferred, and then the regular subordinated debt, tier 2 debt underneath that. Germany took a different approach to the other European countries and said, we are, rather than allow for the two types of senior debt, we are just going to treat all the relevant types of debt as being senior non-preferred, i.e. statutorily they put it in the non-preferred category. Now, so for other jurisdictions, we had a choice as to which level the CDS was going to be put on at. And so ISDA published some additional provisions that could be included in the terms of the senior non-preferred trades, just to clarify where they were, which standard reference obligation they referred to, and just make clear from the transaction type that they were distinct from senior preferred transactions. People didn't use those additional provisions for German bank CDS because there was no need. There was only one level anyway, which was equivalent to senior non-preferred. And so people just carried on with standard financial transaction type. In 2018, however, Germany amended the German banking law to basically put it in line with other European states and said, from this point on, German banks, when issuing debt, can specify whether it's senior preferred or senior non-preferred in line with the other countries. And all the existing debt, which previously had de facto been senior non-preferred, would be treated as being senior non-preferred, continuing to be senior non-preferred, despite the fact there is now potentially this level above it. Now, there was a concern that this would create difficulty in the CDS market, and a question was actually put to the Determinations Committee, specifically relating to Deutsche Bank CDS, saying, could we clarify that trades that had been done prior to July the 21st would be treated at being at the senior non-preferred level. In other words, they would stay at the senior non-preferred level, despite the fact that there is now potentially a layer above that, the senior preferred level. And so the Determinations Committee considered that and made a determination, which is explained in the DC statement of the 14th of September 2018, that basically says that all legacy senior CDS transactions that just refer to being senior CDS will be at the senior non-preferred level, unless they specifically said that they were intended to be at the senior preferred level. They will be at the senior non-preferred level. So I think the effect of that determination was to avoid confusion and avoid certain sort of technical arguments about the reading of the definitions, which could give rise to confusion. And the DC then followed that up. There's another question which then followed up with another statement saying, not only did that apply to all legacy trades, but kind of the presumption going forward, if you just say senior CDS, that's assumed to be at the senior non-preferred level, unless you explicitly say it's intended to be at the senior preferred level. And although those questions were posed in relation to Deutsche Bank specifically, the DC did say that they would take the same approach for any questions relating to any other German banks in the same position. So I think the DC clarified the position kind of looking backwards and clarified a presumption looking forward that absent specific provisions to the contrary, you would be dealing at the senior non-preferred level. But it did leave the issue that for all other jurisdictions, senior non-preferred transactions would trade, including the additional provisions. And obviously what the DC can't do is import the additional provisions into people's transactions. So going forward, although we have the sort of safety net of saying you're at the senior non-preferred level unless you stipulate otherwise, it was a sort of unsatisfactory position because of the fact that the additional provisions would not otherwise apply to Germany would be the outlier and trade on different documentation terms to other European jurisdictions. And so the story then goes, the next stage was the question was put to the CSC. So I'll hand over to Andy at this point.
Hi, thanks, David. As David highlights, we're on slide 4 now. Sorry for those of you trying to keep up on the PowerPoint. The CSC clarified this point on the back of the DC determination, and what David just said is that's it's important to highlight that this really is sort of clarificatory. The German bank CDS differing from French or Spanish or Italian whenever we get there is nothing to do with any difference in the way that the names are actually trading now. It was the way that it was implemented into law that was different. And as a consequence, that meant that we had to sort of look in the rearview mirror when it comes to CDS documentation for the German banks. Causes issues both for the index annexes, and I'm sure that those of you that looked into this are aware of that. So realistically, what was required was from the CSC was this gathering of minds and everyone agreeing that clearly if Germany had done this in the same way as other people, we could have drawn a line in the sand and then going forward, this is how it would have traded. The implementation of it means that we need to ensure that trades going forward and trades that we've done historically are completely fungible. And the only way to really achieve that is to go through this process and have everybody adhere to a protocol so that we can toggle all of the transactions historically over to the same set of definitions that we're going to be trading going forward. There's a huge infrastructure around CDS now, which is why it's taken since November to February to sort of get all the ducks in a row. Clearing houses are looking at this very closely. The regulators are looking at it very closely, and there's an expectation clearly that the clearing houses will adopt this approach. That is somewhat subject to the take-up of the protocol itself. So I would implore everybody to sort of, look at this and, realize that, there really isn't anything to game here. It really is very much just ensure fungibility, ensure retention of liquidity, and so that everything can be on the same set of documentation, both historically and going forward. For that, because it's actually such a neutral change, it's been quite difficult to engage the right sort of people on my side in the front office perspective, trading and sales. I know that there's general reticence to focus on things like this when people see it as largely admin. But as soon as it's highlighted to them, well, okay, there could be some basis, there could be an issue, but the reality is the basis is unlikely to be economical. It's just more sort of a pain when it comes down to it, that you may have some uncertainty. The reality is, you by signing the protocol, you can dispense with that uncertainty, and so that's why we're trying to run this in such a short time frame. The time frame is a little bit aggressive, but we don't see it as being a material protocol. So hopefully we can get it over the line. From this point, I think I'll hand over to Paul, who can run you through what the additional provisions are actually trying to achieve.
Thanks, Andy. So the additional provisions were published by ISDA in December 2017. And as you've heard, these are already used for CDS at the senior non-preferred level in other jurisdictions that aren't referencing German banks. The key thing that the additional provisions do is just make it absolutely clear that the trade is at the senior non-preferred level, and it's the senior non-preferred SRO that you're looking at. So the point of the protocol is to bring into effect these additional provisions. We're not changing the subordination level of the trade, but it is making the legal terms consistent with those that apply to senior non-preferred trades in all the other jurisdictions. A senior non-preferred obligation, as you've heard, it's a senior obligation, but it sits below the senior preferred when it comes to loss absorbing. And obviously it ranks above the subordinated obligations. So when you have your senior non-preferred additional provisions applying to the trade, it just makes crystal clear that the seniority level is that senior non-preferred level.
Great. Yes, thank you, Paul. So the protocol, as has been mentioned, will apply the new terms to your legacy trades. And the way it's been drafted, if your legacy trade incorporates the 2014 definitions and specifies either standard European financial corporate or European financial corporate as the transaction type, and either it has a standard reference obligation specified as applicable, or it has a reference obligation that is specified that was issued either prior to July 21st, and it was a senior unsecured debt obligation, or issued on or after July 21st and was a senior non-preferred debt obligation. It will then change the transaction type to the new standard European senior non-preferred financial corporate or European senior non-preferred financial corporate as applicable. I will note that if there is no reference obligation or no standard reference obligation specified, the protocol excludes those transactions. Now, we understand that these would be non-standard anyways, but it is something to keep in mind when you're looking at your trades, that you will have to address those separately. Now, this protocol will apply to both your single name CDS as well as to index trades, but it only applies the new transaction type to that portion of the index trade. So it won't apply it to any other portion of the index. And that's important because we also had to update the fiscal settlement matrix in order to make sure that that transaction type, the new transaction type, is actually referenced correctly. And of course, the ultimate goal of this is that with the transaction type changed, it will then incorporate those additional provisions that Paul spoke about. So adhering to the protocol is pretty straightforward. And most of you have probably adhered to ISDA protocols in the past. Same thing on your screen, you see a direct link to the protocol website. The protocol is open from February 6th to February 27th at 5 p.m. New York time. We have a very tight time frame for people to adhere to the protocol. This is because the clearinghouses are going to need to know, and all the infrastructure providers are going to need to know, that the protocol has been successful and that people have adhered to it to make the changes in time to make the implementation date, which is March 10th. And that is when the changes to your transactions actually, the amendments actually take effect. We just want to note that, as Andy mentioned, it's important for all market participants to adhere to the protocol. At this point, I think we will take questions. So you should have on your screen a question box where you can type in your question, and then I'll read it out. So go ahead and type those questions. We're just going to take a second to read through them, and then we'll respond. And Andy, I don't know, did you have any final words you wanted to say before we get into the question and answer part?
No, I think you just summarised it pretty well, Fred. Thanks. I mean, I've been sort of trying to do the rounds with some firms, trying to ensure that there is the focus that this merits. I mean, some people, make the mistake of thinking, well, I haven't got any historical sort of, German bank CDS or anything, and so it doesn't affect me. Well, it does because of the constituents of the index. So if you're trading credit derivatives, the chances are you're trading iTraxx indices, in which case then you need to be signing the protocol. Another sort of misconception may be that, well, all of my trades are cleared and I only trade indices, in which case I probably don't need to sign the protocol because whatever the clearinghouse does is what will happen to me, and I'll stay on the liquid contract. No, that's not necessarily true either, because, well, it's just not, because the clearinghouses are using the protocol as an indicator to the course of action that they feel that they should take. And so even if you think, well, I only trade indices and I've only got clear contracts, we still need you to sign the protocol so that the clearinghouse can get that sort of poll, that sort of sense of how many people are taking this up, so that they can then go to the regulators and say, look, 70% of our participants have actually signed up to this now, so we're going to implement this across the board, and then the regulators will give them the sign off, etc. I mean, if you've got any questions about the processing of this within clearing, I think it's right that you contact your respective clearing houses directly, and they hopefully will ratify what I've just said.
Great. Thank you, Andy. So the first question that we have is, what happens to transactions that fail to adhere by February 27th at 5 p.m.? And so obviously, once the protocol closes, you won't be able to adhere. If you wanted to make the trade or make the change, the amendment yourself, it would have to be bilateral, which of course could be a significant burden depending on how many transactions you have. We know that once assuming the protocol is successful and the industry has largely moved to amending their trades, you will have a bespoke trade that you'll have to address, with your counterparty. And I don't know, Andy, David, or Paul, if you have any further thoughts on that. I think Andy's summarized, why that's not recommended.
No, I think as is always the case, if you end up in a situation where you have a bespoke transaction, it's just you versus your counterparty. I don't want to say you're beholden to liquidity provisions, and the bid offer widens. They're all obvious things, but the reality is, it becomes most of us are geared up now for trading very standardized contracts. Most of our systems, everything. So it's more than just a liquidity issue. It's a sort of operational one too. That's all I would add.
Great, thank you. Another question is what level of adherence will be deemed to be sufficient take-up? And I think, generally speaking, well, I don't know, Andy, do you have any thoughts on that?
It's tricky because clearly there's a number of counterparties who will sort of dominate, the outstanding balance of notional here. If you were to take the sort of, top 20 banks, you are almost inevitably going to have, finger in the air, but probably 80% of the existing sort of volume of transactions. So I don't think it's just about numbers. It's about what do we think? Where do we think the liquidity is going to migrate to? If people sign up to the protocol, and that becomes the sort of more fungible, more sort of generic standard contract, then I think the tail will get swept up quite quickly. But in order for that to be achieved after the protocol is closed, it becomes a very manual process. So I think that therein lies the incentive to sign. I suspect if you see all of the banks appear on the list, and there will be a number of large clients, and then you've probably got your answer. And that really isn't that many sort of names, but it's going to be a significant quantity of the existing sort of outstanding notionals.
We have another question. Is it possible to bilaterally amend the legacy transactions? As I mentioned before, the reason we put these protocols together is really to allow for the amendments in the most efficient means possible. So, once again, obviously you can, theoretically amend the transactions. I think, the protocol, we've streamlined it to be as straightforward as possible, providing just the amendments that are necessary to bring the legacy contracts in line with, future trading. So, I think that pretty much answers that. There was a question also about adherence issues for the clearinghouses and for the infrastructure providers. We don't really see any issues. The clearinghouses, obviously, and all the infrastructure providers, DTCC, IHS Markit, they've been working with ISDA and with the industry to make sure that after the protocol is successful, that they're able to implement this quickly. So, we don't see any issues, but obviously if you have any specific concerns, you can feel free to reach out directly to ICE and LCH, and we'll circulate contact information for both of the clearinghouses that they've authorized us to provide if you did have any specific concerns with that. So that's it. I will note that there is another webinar that is going to be provided by IHS Markit in terms of the changes that they're making to implement this protocol. And you should reach out to them. They'll be circulating it to their clients, but they did ask us to mention that is in the works. That's it for the questions. I will open it up to Andy or David or Paul. Do you have any final thoughts before we close?
No, not an answer.
No, I think we've covered everything there. Thank you.
Great. Well, thank you everyone for attending. And if you do have any questions, please feel free to reach out to ISDA. We will be able to answer any questions or put you in contact with the people. I will also note that this webinar has been recorded, and we will be sending out links to the recording. Feel free to share this with any of your counterparties, anybody else at your firm that needs to know, and it will also be posted on the protocol website when it's ready. Thank you, everyone. Goodbye.